Welcome to webinars from Hynes Legal. I'm Chris Hynes, Strata Consultant, former Commissioner of Body Corporate and Community Management. With me, as always, except for last week when I wasn't here, Frank Higginson, partner, Hynes Legal. Frank, welcome.
Hello, Chris. Hello, everyone. And we've gone uncoordinated brown shirts today. It's not planned.
Right. Technically, that one's khaki, I think.
Right. Okay.
But close enough, I guess. Frank, thanks for holding the fort last week. I understand it went off.
I don't know, mate. I don't know whether you're dragging us down or it's just me on my own with my witty personality for half an hour of talking at a camera.
Bit of
column maybe it was the topic.
Bit of column A, bit of column B. Anyway, we're back this week. As always, don't forget to like and share. Make sure you subscribe. That's how you find out what's going on. If you do have a question or a comment today, please feel free to put it into live chat, or if you've got a bit more of a detailed one, link coming up on the screen shortly where you can pose a question to us. Just fill in the form and that'll make sure it gets to us. That link is now up there. So this week, moolah, debt, money, cash, all the rest of it. Body Corporate Debt 101. We have a lot of content today, Frank, and it may well be that we defer to part 2 or even part 3 on this one as we go along, but we'll see how far we get today. Because when you talk about body corporate debt, there's a lot of stuff to talk about, isn't there, Frank?
And money is near and dear to everyone's hearts. It's a great way to get people motivated. So, and there's lots of very, well, you wouldn't call them emotional disputes, but very detailed, actually, there might be emotional disputes where people just basically hate each other over the recovery of levies. So today, it's an interesting one. There's some basics and there's some detail we'll get into, but there's clearly no way we can cover it all. So I think we've made a distinct choice today to try to not to waffle, because if you listen, you can almost take notes the whole way through. There's so much of this when we were planning it out.
But it's as Prince said, money changes everything. And so same here as well. Probably just a note to kick off. So one part of the firm that we absolutely do work in is debt recovery. Use that link that we've just posted there in relation to debt recovery, but that works both ways as well. So if you are a lot owner and you've got a particular issue with debt that you're not sure about, there's some contention around that, you can also take a look at that side of things.
We are mercenaries.
We are indeed. I guess, Frank, when we talk about what's a body corporate debt and all of that sort of stuff, I reckon there'd be some people watching and goes, well, it's a no-brainer. You owe money to the body corporate, it's a debt, right?
No. So, and we get this a little bit too. And just because so let's take well, back a step. We probably start with budgets, don't we? So everyone goes to their AGMs. There's a budget every year, admin sinking fund. Levies are raised pursuant to those budgets. And bodies corporates they're definitely not creatures that have discretionary spending. So we can choose to go on holidays, have staycations in Brisbane, Chris, or go whale watching or whatever it is we choose to do. And that's our discretionary spending. Bodies corporates don't do that. They've got certain statutory responsibilities to do a bunch of things, not the least of which is insurance, repairs and maintenance, maintaining common property, obviously administrative costs and all those sort of things. Those are in those budgets. Anything that's raised in a budget is going to be really, again, subject to some exceptions, body corporate debt. And that's really what we're talking about today.
That's right.
The difference that some people get caught up in is if Chris is moving an owner-occupier, he's moving into his unit and he accidentally damages the lifts with heavy, bumps the cabinet into the lift and breaks the window. And the body corporate says, mate, that's $3,000 worth of damage. Now come and fix it. Where some people go wrong is they'll put that $3,000 on Chris's levy bill, and it's actually not something that he's been levied. It's not a body corporate debt. That's a civil right. The body corporate's got to pursue him for damages to common property. There's a big distinction there. So just because Chris happens to own a unit in the scheme doesn't mean that any amount of money that he might owe the body corporate, allegedly or otherwise, can go on that levy statement.
Yep.
Really important to get that clarification up front.
And let's start with let's go with another important clarification. A body corporate needs money to survive. That's the bottom line. It needs money to operate. Look, it needs money to maintain common property, but it needs money to fulfil its obligations in relation to insurance. That's one of the big things. So if you don't contribute as part of your levies, then those obligations will not be met, and there are huge consequences of that. Just imagine having an uninsured building and then something really terrible happening. You will be liable for that as a lot owner. But of course, Frank, the other big implication of not coughing up levies when you owe them is that you're unfinancial. And if you're unfinancial, what does that mean?
Well, you don't get to vote at general meetings.
Right.
And if you're on the committee, you're now officially a debtor member with the new regulation modules that kicked off in March. And you can't vote on committee decisions. And if the person that nominated you isn't financial, then you can't vote on committee decisions. So you effectively lose your right to participate in the day-to-day running of the body corporate. So subject to how near and dear that is to your heart, that can actually be quite a consequence. You know, in a court, obviously there's been some litigation about levies. A judge once said levies are the lifeblood of the body corporate. And they're right. It's we call it a necessary evil. It's just the reality of it.
You've got to pay. But the flip side of that, the body corporate has to collect as well. And so we'll be covering that a bit more today. So as Frank said at the start, levies all start from the budget. The budget is passed at the annual general meeting. So for anyone who, and we hear this all the time, owners complain about levies being too high, or where does it all come from? It all comes from budget. That's at an AGM. And so if you're an owner, you vote on that. So that's how you get the oversight on that sort of thing. With that then, having your levies set from the budget, then we all go on, that then proceeds to what you said then, Frank, about creation of a debt. The non-payment of the levy creates a debt. So there are some qualifiers around that. Probably one of the biggest ones and the misconception, there's no provision to waive levies that are due and payable, are there, Frank?
No. And that's basically the legislation. So the committee's got discretion to waive interest, potentially to waive penalties or reinstate a discount, but it cannot waive effectively what you'd call the principal amount that's actually owing. And where committees need to be careful in those things, and of course this got litigated a bit in your former office, didn't it, Chris, in terms of special circumstances and all those sorts of things. Where committees, I think, need to be careful on these things is consistency. You know, you can't have sort of one rule for some and one rule for others. So you've got to be real careful to make sure that if you are waiving interest, for example, that you do it consistently across the whole of the building when people request. And again, everyone's circumstances are slightly different, but again, back to blanket policies, I don't think it's, well, as we've said repeatedly, it's not reasonable to have a blanket policy to say we're never going to waive interest, and it's also not reasonable to have a blanket policy to say we're going to waive it every single time someone asks. So again, one of the joys of committee membership is you've got to be a little bit flexible in your thinking from time to time.
That's right. Now, we've got this thing called COVID at the moment. It feels like we've had it forever. There are some specific regulations around COVID when it comes to body corporate finances. Just going to put up a link now to my former office and some information it is published. This is a very good summary. Frankly, we don't think we could do much better, so that's why we're putting this link up. While there might be some emergency provisions around COVID, there's still no actual kind of waiving of levies per se. What there is, Frank, is kind of a debt holiday, would you call it?
Relaxation on certain statutory obligations. Yeah. So for while COVID exists, and these regulations expire at the end of September, but given what's going on in New South Wales and Victoria at the moment, you can see them very much being extended out again. So at the moment, bodies corporates aren't obliged to sue to recover levies. We're not talking a minute about that. They've got that obligation otherwise, and they're not entitled to recover interest on levies that have become overdue during this COVID period, which is back to March last year now, isn't it?
And up to 30 September at the moment, yeah.
Yeah, so it's probably, we'll throw that as a caveat. It's worth having a look at that link that Chris has put up if you've got a specific question about levies in COVID right now. One of the things we do with these webinars is, of course, they go online, YouTube, our website, so people might be watching this in 2023 and who knows what the rules are going to be then. But probably that's as much as we'll probably say about the COVID relaxations for the moment. If you want, you can probably go back to the webinar we did on it when they first arrived. We did a regular on the modules. Might find that and put that up later on, where we spoke about it in a lot more detail. So those same rules apply now as they did then.
Probably a point to note, Frank, is that one of the problems with a debt holiday is that the holiday finishes at some point, and like any holiday that you take, you're going to have to pay for it eventually, and the same applies here. So if you have a debt holiday, eventually the body corporate's going to have to recover that money somewhere.
Because the body corporate expenses don't stop.
That's right.
Owners' obligations to pay them might, but our body corporate's obligations to continue to run the business of body corporate don't.
I have not heard of insurers providing premium holidays to bodies corporate, so that's a good example. And just finally on the topic of COVID, before we move on, there was a recent adjudicator's order, and you might have seen this on our social media in the last week or so, where the adjudicator said that while there were regulations around COVID and COVID-related financial hardship, COVID-related financial hardship was not an excuse to stop maintaining common property. In other words, just because you had some reservations about paying money to maintain common property, not an excuse to do it. Really important point to bear in mind. So we've talked a lot about body corporate debt, Frank, but what is it? How is it defined? I know all of our viewers love definitions. How about we put that one up?
I think it's probably easy enough to do that. So, effectively, the contributions levied pursuant to those budgets, penalties for not paying the contributions, which can include interest, recovery costs and those sort of things, or another amount associated with ownership of the lot itself. So the examples they use in the legislation are that it might be an annual payment for parking under an exclusive use bylaw. So what some people might not know, and you can't retrospectively do this, but if someone's got the right to use exclusive use under an exclusive use bylaw, it can be a condition of that exclusive use that the person pay a rent or other license fee for that for the purposes of the every year. So that is associated with the ownership of the lot. So again, that's not what I was talking about before with Chris damaging the common property when he's moving into his unit.
Yeah.
So there, bang, that's the statutory definition.
That you will find that, everybody, in Schedule 1 dictionary in the regulation module. I've had to put that up there in a series of posts because it was too much for one post. I didn't know that. There you go. You learn something every day.
Twitter limit on YouTube.
Yeah, so it's there. So that's what a body corporate debt is. So, Frank, is 2 cents owing on a bill a body corporate debt?
Yes.
That's
it's the same. Can you be half pregnant? The answer is no. You are pregnant or you're not. You owe money or you don't. So 2 cents is a body corporate debt. I think it's also been litigated in the Commissioner's office, is that if Chris owes money, sorry to make you the recalcitrant in all of these stories, Chris.
Yep.
If Chris owes a body corporate debt and he comes to the AGM and he gives the body corporate secretary or body corporate manager a check for that debt before the meeting starts, Chris is then financial, even though it's not cleared funds. So if it bounced later, you might look back at looking at what his voting positions were on those matters, but you're entitled to assume that if he's given you a check, that it is cleared. So he's then financial.
What about recovery costs, Frank?
They are, to the extent they're reasonable. So again, lawyers' fees ever reasonable? There you go. And there's 2 types of recovery costs here, really. There's the body corporate management companies that usually have a churn and burn machine that sends out reminders and charges for that. And then there's obviously the lawyers when it gets too serious after that. So we wrote a newsletter on that ages ago, which Chris will put up now. And I think if you look at that, one of the things that still drives me nuts, I think the cost in this one ended up being near enough to 300 grand, arguing over $15,000 worth of levies. So there's still, in my mind, I'm not sure where it actually got to, is spending 300 chasing 15 reasonable? And I think probably the courts tend to look at the conduct of everyone through those things, but it's interesting in terms of the commerciality of that. But otherwise, reasonable recovery costs are a body corporate debt.
Absolutely. So, I mean, that then leads to, I guess, one of the more frequent disputes that pops up here, Frank, where an owner is told that they owe a debt and they dispute either that they owe the debt at all or the amount of the debt. And it's a really, really common dispute, argy-bargy between the parties. There may well be a genuine misunderstanding that's led to it, or there may be a genuine debt. In my former office, and we used to do this all the time, people would bring in with this issue and we would say to people, look, given that non-payment means you're unfinancial and you can't vote, you're much better off paying the amount and then arguing it or trying to dispute it after the event, which makes a lot of sense, except...
And it was exactly the advice we were giving as well, mate.
Yep. Except there's been a recent decision in QCAT, hasn't there, Frank, which alters that significantly.
Absolutely. And that QCAT decision says that if you pay it and you've got arguments about the validity of it or otherwise, payment actually acknowledges that you owe it. So you lose the ability then to challenge it. So, which actually changed quite a few people's perceptions on that process. So I think probably where we've got to now is, I think that QCAT decision did say if it's a genuine mistake that you're not aware of it, then that's okay. But if you're paying it under protest and you think you've got an argument about validity, payment says that you don't care about that. So what's that mean? That means in a practical sense that if you have an amount that you don't think you should be paying, first thing is to pay the stuff that is absolutely guaranteed as owing. So I suppose the core of the levy. If your argument is about recovery costs being reasonable, use that as an example, maybe you file an application arguing that they're not reasonable and that you should be entitled to vote until you get a final order on whether they are, and then you ventilate that in the Commissioner's office. So, but yeah.
We've just put up the link to that case now.
It's an interesting one because it was really, changed the way everyone's been operating.
And look, it then comes back to a strategic decision for you as a lot owner. What's more important to you, the principle of the matter or being able to vote on it, knowing full well that you might not have the option to recover it later on? It's a tough one, that one, really tough one. And you might, I suspect, or you might need to get some qualified advice about what are your options in that regard. So, having said all of that, let's talk a little bit about debt recovery, Frank.
Itself, absolutely. So, like I suppose most processes in these things, there's a couple of, the vanilla debt recovery process is a reminder, a couple of reminders, nasty letter from a lawyer, and then, proceedings themselves. So I suppose it's really interesting in this one because it's the legislation has a couple of very unique things in it that don't exist in relation to other recoveries. So for example, if a client doesn't pay us, we can sue if we feel like it. It's completely up to us. Rate of interest is set by our client fee agreement, which is negotiated each time, et cetera, et cetera. And we've also got an overlay of the Legal Services Commission, making sure that we're not doing things that are adverse to clients' interests without telling them and all sorts of stuff. So there's an element of constraint with respect to lawyers, but also it's a little bit flexible. From a BCCM perspective, it's not that. So the way it works from a BCCM perspective is that levies, overdue body corporate debts, carry interest at a cost or a rate of 30% per annum, 2.5% per month. So, in one sense, in this conversation with clients a little bit over the years, 30% return on anything at the moment is an extraordinary return. So why wouldn't you let it run? So there's that element. So that would be usurious. Usury? I don't know how you can pronounce that. My mum's watching this and she'll be chopping me up later on for not knowing that, but there you go. The other thing that is in the strata legislation that is unique is there's actually an obligation to commence proceedings. So if a body corporate debt has been outstanding for 2 years and 2 months, the body corporate must commence a proceeding to recover it. And I suppose that's driven around committees not necessarily wanting to do what is sometimes the dirty work of body corporate business in terms of pursuing people that haven't paid their levies, but there's a statutory obligation to sue. And I couldn't tell you another piece of legislation that has that in it, particularly when it comes to, for a better phrase, mum and dad consumers on the receiving end of those things. So that's one of the things that COVID, that obligation to sue has been relaxed during the COVID regulations. The ability to recover interest has been relaxed, well removed under the well, both of those have been removed under the COVID regulations that'll come back inevitably when those things go away. But they're two really, really unique things inside Strata. The other thing then from a proceedings perspective is that being obliged to commence it is one thing, how aggressively you prosecute is another. And I suppose, you know, where we get down to is it's sort of each individual's committee's decision as to how they want to run these things. You know, spending 300 grand chasing 15 is just insane. Forcing, you know, the sale of a lot through a bailiff can be very expensive. And one of the things I think that needs to go into the mix, well, a couple of things, is firstly, the reality is if people aren't paying their levies, they're probably not paying other things. So they may not be paying their mortgage. They may not be paying their rates. If they've got land tax, they're probably not paying that. So what can happen, particularly in real estate that is lesser in value, is that those expenses can all add up with the relative interest rates that everyone can charge, to the extent that you might have something with no value in it anymore. And we both know some examples of those. So you'd almost call them zombie lots, where the amount that's owing on them is worth more than what the real estate actually is. And that is a shocking place to be for a body corporate. So you can't let it run forever. The other thing is, from a lot owner's perspective, if they're struggling to pay 5 grand, they're going to struggle to pay 10. They're going to struggle even more to pay 15. So the longer you leave it go, the more difficult it is for the body corporate to actually get back to where it should be in terms of having that owner contribute towards the maintenance costs of the building of which they effectively own a share. So there's all of those sort of things that go into it. I mean, actual litigation itself, I mean, that in a sense is relatively simple. It's, Chris, you owe me $1,000. I'm going to go and commence a proceeding against you to seek an order that you pay me that $1,000. You know, that's not rocket surgery. There's all the sort of behind the scenes stuff in terms of whether it's the right thing to do, how to manage it. And really, one of the things that can happen with these things, and I know on my little soapbox now, aren't I used to do, oh, here you go. Frank's former careers. I went to London in the late 90s, and I had a job there doing debt control for a minicab company, which is like Uber's before Uber's existed, private car services. And so my job was to chase all of the debts. So people that hadn't paid their accounts, all that sort of stuff. So I suppose you get relatively good at rigging people and say, hey, if you don't mind, I work for, you owe this. Are there any problems with the bill? Would you mind fixing it up, et cetera, et cetera? And I suppose this is before we're taking credit cards over phones and all the rest of it. So people are sending checks. And so you do get a handle on it. So I think one of the things is actually being a bit sensitive to the fact that people can be embarrassed, is from body corporate side of things, by not being able to pay their levies. No one usually runs around. Some people do, but most don't, willingly ignoring bills that are owed. So they might be in some sort of circumstance that they can't control, and particularly in COVID, and that's what the regulations are about, is reaching out to them to find out what's going on is a very, very sensible thing to do before you rip straight into threatening to sue people, because that gets people's backups. And I know our process internally is the lawyers will make a phone call with a bit of a script to anyone who owes money to say, mate, really sorry, but this is where it's got to, and this is where it will go to if this doesn't happen. So can we reach a payment plan, get an understanding where it is? And that cuts a lot of it off. It really does. So
and then Frank, there are the very physical, practical realities, such as, is the email address right? Did you key it in correctly into your database when you're sending out the notices? Have you been checking for bounce backs for that? So
we're now on an opt-in, we're an opt-out system now, aren't we? So if an email address is on the body corporate record, that's the address.
That's right. That's right. So I think the point we're making there is that there is a world of difference between somebody who is refusing point blank to pay on principle because they're a sovereign citizen or some other rubbish, or that they can't, they literally can't, or even worse, they didn't even get the levy notices. We've got a couple of queries there, which we might address those now, kind of sort of on that topic. So I might go back to the first one from Julia. Julia, thanks as always for tuning in.
Mate, I can answer this one. This is easy.
Yep.
So, so special levies are levies that are outside the normal, You know, so we've got a budget for admin and sinking funds throughout the year, and then suddenly we realise, whoa, we've got 100 grand's worth of retaining wall that wasn't in there, so we need to raise a special levy of 100. So Julie's question is who pays for that on settlement. So I can tell you the standard contract, REIQ contract provides that if the levy is struck before the contract date, it's the seller's problem. If it's struck after the contract date, it's the buyer's problem, but that's a matter of contract. That's not a matter of BCCM.
Yep.
So just, and then it's adjusted on settlement one way or the other.
The rule is the charge always stays with the lot.
So it's going to be paid by someone. Just the question of that someone depends on what the terms of the contract are that they've signed.
That's right. Nicole, thank you for your question or your comment, really. So you have an owner who's refusing to pay arrears on the basis there were delays in repairing the ceiling in her unit. So this is something which happens quite frequently. Yeah, where an owner says, well, because you did not do X, therefore I'm not paying levies. Now, there was a court case not so long ago, Frank, where that was actually litigated, that particular one.
It's not even ringing the Vegas to bells, but I bet you the answer was that just because the body corporate hasn't done what it should doesn't prevent you from being obliged to pay your levies.
Well, that's what I want to say, except I'm not sure that was actually the end result.
Really?
Keep talking, Frank, while I try and rapidly find that one.
Because there's nothing in the legislation that says that you could offset your levies against body corporate statutory obligations to do their things. Because what I would have thought, the process there, if the body corporate's not doing what it should be doing, then your rights as an owner are to bring a commissioner's application against the body corporate to seek an order that it comply with its statutory obligations to maintain and repair common property, et cetera, et cetera, et cetera, to the extent that you might even appoint an administrator to actually do it. But if you can find something to the contrary, that'll be interesting. The other one that I might mention just quickly before I suppose we get into some of the best practice stuff, which is always the good bit, there was a bit of a kerfuffle in a debt recovery proceeding up in North Queensland a couple of years ago where a judge said, oh, this 2 years, 2 months thing is a limitation period. So if you haven't commenced proceedings inside that period, you're statute barred from doing it. So limitation periods are usually 6 years in civil matters and 3 years in personal injury ones. And if you don't do what you've got to do and that's inside that time frame, it means you lose the right to do it. So that I wrote a newsletter on at the time, which Chris will put up, that got knocked on the head pretty quickly on appeal, thank goodness, because at that stage there were conniptions. A whole bunch of people hadn't commenced proceedings, which would have meant then that the body's corporate weren't entitled to recover those. So you found your case yet, Chris?
I have, but I am rapidly rereading it just to make sure I'm talking about the right thing. So I won't put it up now.
No.
We might refer to that next week or in the interim, everyone.
Yep.
Another question, Mr. SMB, another frequent viewer. Thank you. Does granting an owner a license to use non-exclusively a portion of common land necessarily indicate an amount associated with a lot?
Off the cuff, I suppose the starting point would need to be if there's a fee for the use of the license, possibly, but license isn't a lease and a license isn't an exclusive use grant, and it probably could be independent of the lot itself. So an exclusive use grant attaches to the lot. So so it attaches to it regardless of who actually owns it. The license agreement might not do that. So I think that's a question of characterization, which is beyond the scope of my ability to give you off-the-cuff advice in this little webinar.
And a follow-up question from Nicole, do strata managers need permission for each step of debt recovery process?
Permission as opposed to instructions, it's interesting. So probably, to me, best practice for strata managers would be saying to committees at the start of every financial year, this is the process we're going to adopt for debt recovery. Are you all okay with that? Yes, we are. And then they charge on accordingly as required. So ultimately, strata managers are creatures of instruction like we are, shouldn't really be doing things that they're not instructed to do, but I'd suspect that's how most of them operate.
I would suspect so too. Yeah, that's my understanding. So best practice, I think we've already covered this to a certain extent, Frank. I think we talked about from the committee's perspective is to not make an automatic assumption about somebody who is in default. But for the lot owners, I think the reverse is also true. If you know that there's no choice for the body corporate to pursue you for that debt, try and be proactive about it. If you know it's going to be a problem or it is a problem, you're in a much better position to be proactive about that rather than wait for it to happen. And yeah, sorry, Frank, go on.
So the reality is it's a bit unfair to sort of not pay your share of the costs of running the body corporate when everyone else is. That's just the reality of it. So, you know, it's sort of, there's a commitment that comes with ownership. That commitment is bearing these costs. So, and the reality, if they don't go away. Body corporates can't write them off. They can't get ignored. So at some stage, there's going to be a day of reckoning. So if you can't afford it, or you've got issues with payment, you want a payment plan or whatever, reach out and get on the front foot.
And then another question there, just to finish off from Michael, in terms of the time, thank you for tuning in. In terms of the timings and reminder notices and the letters of demand after levies are due, do you guys have vanilla template for this sort of timing? Drop us a line, please, Michael, and we can talk with you a bit more about that. Please use that link right at the top of today's chat. Give us your details. We'll come back to you. We've reached the end, Frank. I'm really pleased with our efforts there.
We stuck to our timing, and I think there's so much content there which we still haven't covered, but that's a lot of content regardless, I hope.
And I suspect that people watching this either today or after the event might have some follow-up questions. If you've got some other debt-related questions, please shoot them on through, because I dare say they could constitute their own webinar as well another time. Next week, though, Frank, it's the end of strata schemes.
It is. So I suppose what happens when no body corporate levies are paid? The strata scheme can't. No. So, and this is actually a viewer-initiated webinar. So, and we get this a bit, and you get this in rising property markets, which we are now, amalgamations and all that sort of stuff. So we're talking about what that looks like. I suppose, Chris, we are both in the Strata Title Law Reform Working Group, where this is a topic of conversation, which is one of the first things that came out. So I suppose we will say what we can say about that particular process at the moment, but there's certainly a policy paper out there that was put out a couple of years ago. Maybe we can refer to that. So it's a really interesting one. How do you bring a strata scheme to the end? What's the relationship between the lot owners and the body corporate and developers? And I suppose we might even contrast that with what goes on in New South Wales.
Indeed. So stay tuned for that, and that'll be good. So that's next week. But for now, Frank, thanks very much, as always.
Thank you, Chris. Thank you, everyone, for joining us again.
Thanks. Much appreciated, everyone. We'll see you all next week. Bye-bye.
Bye.